monthly webinar. And today our Center for Internet Law and Policy is very happy and proud to host Sandra Colino with her new paper on one of the most landmark paradigmatic cases in the contemporary competition law sensu lato in state aid policy. Sandra Colino is known not only as the author of one of the most well-read textbooks in competition law, published regularly by OUP, but also as a kind of purely academic thinker, and her research is remarkable. So I don't want to occupy floor for too long. Without further delays and procrastinations, let me welcome Sandra Colino to our webinar. The floor is yours, Sandra.
All right, thank you so much. For me, it's such an honor to be speaking at Glasgow University. As you know, you mentioned on Twitter that I was an honorary Glaswegian. I really hope that you see me like that. I lived in Glasgow for 5 years. That's where I started my academic career. And I just, I can't wait to go back. In fact, I should be going back in January, but now with COVID, it's probably going to be later, but hopefully still happening. I'm still hoping. So what I'm presenting today, let me see if I can successfully share my screen with you. You should now be able to see my slides. I'm hoping that you should be able. Let me see if I can do, yes. So I recently published, I recently wrote a paper that's going to be published in the journal, in the Fordham International Law Journal. And the questions that I dealt with, just to cover a bit, to explain to you where it came from and how I came to this idea. Well, as Oles just said, only this summer we had one of the biggest, one of the most important ever decisions made by the General Court regarding a very well-known case that made headlines around the world. You might remember that Apple, the tech giant, was asked to pay no less than 13 billion euros in taxes, in supposedly unpaid taxes to Ireland. Now, it seems the argument of the Commission was that Apple had a sweetheart deal and that was not offered to other competitors. We will talk about that in a moment. And therefore they got an advantage that they shouldn't have got, which affected competition, and therefore state aid law was applicable, and this was amounted to illegal state aid. And therefore, the taxes could be claimed back, should be claimed back. Now, interestingly enough, this summer, the decision of the Commission was in 2016. This summer, the General Court annulled the decision. And it didn't annul the decision because it didn't think that state aid law could be used to target such state aid rulings, such tax rulings, but because it didn't find that the Commission had provided the necessary evidentiary burden. In any case, we will get to that in just a moment. Let me just show you a bit about, so effectively the paper asks whether or not state aid should be used as a tool to fight corporate tax avoidance and harmful tax competition. We will explain these terms in due course, so don't worry about that. And I will analyze, since we've got very little time, I'm going to focus on Apple, but let me just tell you also that there was 2 other decisions in late 2019 relating to Fiat and Starbucks. Now, in Fiat, the Commission won, and the court confirmed that the state aid granted was illegal. In Starbucks, Starbucks won. So the Commission has thus far lost against Apple and against Starbucks, but it has appealed the Apple decision, and the General Court will be making the final decision at some point. So just for you to, I hope you can see my slides here. So in 2016, and as I was saying, Apple was asked to pay 13 billion in unpaid taxes. And I think it's important to see here one of the statements made by Commissioner Vestager in the press conference given relating to this case. She said that for every million euro in profits, Apple paid just 500 euros in taxes. And so just it gives you a sense of the magnitude of, let's say, the sweetheart deal, the special treatment that potentially, it seems that the Commission alleges that Apple was granted. Now, let me just show you what that looks like in practice. So I've compared here the taxes. So this is from the year 2011, and there's a relevance to this. Now, these are the taxes paid by Apple compared to the taxes paid by Walmart. These are two US companies, and they're both, as you know, big, well-known, established firms. And you can see that Walmart made just under 25 billion US dollars, and its tax bill came to about 6 billion. And yet, if we look at Apple, it made in excess of 40 billion US dollars, and yet it paid 2.4 billion, I believe, was the tax bill that year. So it clearly seems that we see that in absolute numbers even, we can already see that Apple made more profit and yet it paid less tax. So why is that? How does this happen? Let me first tell you that the reason why I'm giving you 2011 figures is because the first, I think when this really became an issue that it began to be discussed internationally, widely, there was two things. One was an article published by the New York Times in 2012, which precisely highlighted Apple's tax system and explained how Apple avoided paying huge amounts of tax. So these figures were from the previous year, and they were published in this New York Times article that brought this to light. Now, in 2014, you might have heard about the LuxLeaks scandal, when a lot of the tax information of a lot of companies, including IKEA, including Starbucks, including Apple, including Google, was made public. And it was basically, these leaks showed how these companies established very complex structures using their international presence to really drastically reduce their tax bills. So this is really what maybe captured the public attention. Although I have to say the Commission was already investigating by the time the LuxLeaks were published. So let me just show you how it is possible. So why do Apple and Google, they are probably the ones that we know best, and there's been so much published about Apple and Google. How did they manage to get these tax deals? Well, what do we need in order to be able to benefit from such such a low tax rate? Well, first of all, there need to be different jurisdictions with different tax rates. Of course, these companies, what they do is they look to see which tax rates are more beneficial. So for instance, Ireland indeed has a lower tax rate than the US. I think the tax rate in Ireland is about 12.5%, and in the US it's over 25%. So already that's a more beneficial tax rate. But also sometimes they benefit from regulatory gaps, meaning that sometimes some profits will go untaxed in both jurisdictions. We talk about ocean profits. So they manage to, there's a loophole, and they manage not to pay taxes in Ireland at all, and also not to pay for the same profits, not to pay taxes in the US. And that's perhaps even more worrying. So also it's normal that multinational enterprises are the ones benefiting from these schemes, because they have presence in different countries. And that is necessary in order to be able to move around the profits, let's say. So what we find is that these companies often establish very complex systems in order to cut down what they have to pay in taxes. So another important thing, and I think this is maybe the difference between Walmart and Apple. Apple is a big tech company, as we know, and it means that it has significant intellectual property rights. And I think this is where maybe this topic becomes increasingly significant for in the context of these seminars that we are now attending, because what the companies do is that they use this IP rights in order to shift the profits. So let me give you an example. I mean, Starbucks, it's not a high-tech company, but what they did in order to shift their profits was to say that one of their companies was paying very, very significant amounts to another company because they needed to pay for the know-how of roasting the coffee beans. Now, okay, you can wonder how much, the extent to which that can cost such amounts of money, but you can already see why Apple, a company like Apple, would be able to do this much easier. They have significant IP rights, and that means that they can justify, one of the companies can justify that they're moving profits to another jurisdiction because they're paying for the use of those IP rights. So that's it makes it just easier to move profits from one jurisdiction to another. And I think that is one of the most significant differences between Walmart and Apple, and why Apple can benefit from such huge cuts. So what the result of these practices is something that we call transfer pricing. Now, transfer pricing normally there's no problem with it. So it just means it's the process of allocating profits between the different parts of multinational enterprises. But when this is done with the purpose of paying taxes in low tax jurisdictions, then that becomes what has normally been called transfer mispricing, because sometimes it's a bit of an artificial shifting of profits. And what is done is that often we talk about hybrid mismatches. So the companies do establish arrangements to exploit the differences between tax regimes and also these tax loopholes that we were talking about. So then in the end, we end up with something called domestic tax base erosion and profit shifting. And this implies tax planning strategies used by multinational enterprises that exploit these hybrid mismatches to avoid paying tax. And this has been at the forefront of the focus of the OECD's action in recent decades, I would say. As you can imagine, a lot of OECD countries are countries where you pay high taxes, and they are suffering from this profit allocation, this profit shifting, and therefore this is a concern, and they want those profits to be taxed in their jurisdictions, and therefore they have tried their best at least to get their member states to compel. And since it's 37 countries, already a significant number of countries that are trying to take action in this regard. Right, I included here, so I talk in my paper about the double Irish, and that is just one of the methodologies or methods that these companies use to move around the profits, and it's very famous, and it uses a loophole between the Irish and US legislations, and just, yeah, as I was saying earlier, it's just a way to, a lot of profits then remain ultimately untaxed, because they're sent to they according to Irish legislation, they can be taxed in the US, because the parent company is supposedly in the US, but sometimes they are cited in Bermuda or another sort of tax haven, and then they don't pay taxes also in the US. Now, in addition to that, they can sometimes throw in like what we talk about a Dutch or a Luxembourg twist, which manages an even further reduction of the tax that the companies would have to pay. Now, Apple's tax system looks very much like a double Irish sandwich, as did Google's system until very recently. Now, Google has not been under investigation. The tax system of Google has not been under investigation in the EU, but Google has already committed to ending that tax system that they had. So clearly the pressure is real. So what are the problems associated with these tax structures? Why do we want to tackle them? I mean, think that actually some authors would tell you that, well, why can't some countries just increase their profits and do better by offering lower tax? You know, it's maybe the only way that they can do better, than they can attract investment. But the issue is that they're attracting investment that has really been generated elsewhere. So it's a shortcut to economic growth, of course, but it means that it can trigger a race to the bottom. We could, if nothing is done, it means that jurisdictions might be competing to offer better and better tax rates, and we also end up with what we call a migration of intangibles, and that leads to sometimes job cuts in the countries where let's say these profits leave, or if we have countries establishing companies in other lower tax jurisdictions, then those countries would lose, are not really creating employment, although their companies are generating this wealth. If they are really employing people in other countries, then that wealth is not really materializing. And then also if there is less tax paid, of course, there is an immediate impact on government revenue. And ultimately, this can result in tax avoidance, legal or illegal. Of course, this can be discussed, but definitely we know that in some cases there are profits that are simply not being taxed, and of course that is a concern. It's not just that they're paying the Irish tax rate; it is that they're using this very complex structure to avoid paying taxes on part of their income, and a significant part of their income, I would say. So we have different efforts to combat tax avoidance. And we see that there is national legislation. I think about 50 jurisdictions, I would say, to date have adopted some kind of laws to avoid harmful tax competition and tax avoidance. But the problem is that the systems that we're talking about today go beyond national borders. These are transnational problems. Sometimes they're tackled in bilateral treaties, but the most effective to date have been the multilateral actions. So OECD and of course the European Union. Now, let me just give you a bit of an overview of what has been done. And I want to move quickly to state aid, so this is just going to be very brief. The important thing that I want to emphasize that there is a wide recognition of something called the arm's length principle. And this has also appeared in state aid law, and that's why I want to focus on it. So the arm's length principle started in the US and has been recognized by the OECD. The Commission has adopted it in Europe, and now the European courts have also acknowledged the validity of this test. So this test basically establishes that transfer prices should be similar to those that would have occurred if the operation between different members or different companies, part of the same group, had happened between two independent companies and would have been dictated by market forces rather than by thinking of tax benefits. Now, of course, this seems like a very straightforward principle, but if we want to apply it in practice, we have some challenges. The first is that it came up in the context of tangible goods, so shifting around tangible goods. Now we are talking about intangibles. Today we've been talking about IP rights, moving profits on the basis of IP rights. And sometimes it's not so easy to apply the arm's length principle directly in such situations. It's also very broad. It needs a specific calculation method. And sometimes there are disputes. We've seen even in some of the state aid cases, there are disputes as to which method should be applied. And then, of course, that requires the Commission and the European courts entering into a discussion about which method should be applied. And the extent to which we want that to happen, of course, is questionable. It also requires cooperation in good faith between the tax authorities and the multinational enterprises. And that, unfortunately, again, as you can imagine, doesn't always happen. So just some shortcomings in relation to this principle. Now, just very briefly, the OECD work has been mainly a way to, has discussed mainly focusing on or targeting tax havens and preferential tax agreements. Most of the work is non-binding, but of course, the countries, the 37 members of the OECD tend to abide by whatever is decided. Now, the EU has done different things. So on the one hand, you know that direct taxation is a matter of national law. Each member state has the power to act. And there's very little normally the EU can do. But on the basis of Article 115, i.e. The power that the institutions have to adopt legislation for anything that relates to the internal market, the functioning of the internal market, some legislation, some directives have been adopted already. And I have a list here in this slide of some of the directives. I have a full discussion in the paper, and I don't want to go into this because I want to move it to the state aid aspects. So perhaps the most important step to date is the Anti-Tax Avoidance Directive, which has just been implemented now. It's a 2016 directive, but as you know, the member states have some time to implement it into national law, to implement the necessary changes. And I think in this year, 6 member states were called upon saying, hey, you should have implemented this by January last year, and you haven't. So we're still seeing some final implementation in some of the different member states. But anyway, so this is very useful because this, of course, forces the member states to adopt legislation to prevent these kinds of situations and to minimize the risk of tax avoidance. But what is the relevance of state aid? So why do we use state aid, and why is it helpful to resort to state aid? Well, there's a couple of reasons why state aid is particularly helpful and why perhaps the Commission prefers to use it. And one is, of course, that the Commission has exclusive competence over state aid, and also that it can actually look back. So all these measures that we're talking about now look towards the future. So countries from now on, they will not be able to accept or to allow such taxing strategies. But what do we do about the past? What do we do about these unpaid taxes that have been unpaid for so many years? Well, the only way to target these right now in the EU would be indeed through state aid. So saying that these regimes were illegal, amounted to illegal state aid, and therefore we can claim, we can try to compel the authorities to pay. So let me just give you some background of this, and I promise you I will not take too long. So the Commission first started looking at these sweetheart deals offered by the tax authorities in 2013, a year before the LuxLeaks scandal that I was talking about earlier, and coinciding with actually a lot of action that was taking place at the OECD level. So it stems from really the discussions within the OECD. Now, by this summer, there were 12 investigations that had been launched. 8 had concluded. There had been 7 findings of illegal state aid, including Apple. And of the appeals so far, only one has been won in the Fiat case. The Commission won the Fiat case. Starbucks and Apple, as I said earlier, have been lost. The aid was not ultimately not declared illegal by the court. But we know that Apple, an appeal on that judgment relating to Apple is pending. So just to now going into the Apple case, the Apple decision. So the system established by Apple. So what is challenged in the Apple case? So the Irish Revenue had issued a tax ruling in the 90s, and then a new one last decade about the tax paid by Apple Sales International and Apple Operations Europe, which were cited in Ireland. Now, these companies were managed and controlled by a company that was a tax resident in the US. So the profits were internally assigned, as I explained earlier, by the methods that I explained earlier, to the head office. But these head offices, according to the Commission, did not have any employees. They were not located in any jurisdiction ultimately, and did not have the capacity to generate income from trading. So this meant that these profits were not taxed anywhere. And in 2011, the profits of 22 billion made in profits by one of these companies, only about 50 million were taxed in Ireland at this tax rate of 12.5%. So this is how the tax rate was effectively cut to 0.05%, and then even dropped further in subsequent years. So according to the Commission, this amounted to illegal state aid. And this was by applying Article 107 of the TFEU. For applying Article 107 of the TFEU, we need to find state that is, we need to find aid that is imputable to the state. This was quite straightforward. Clearly, these decisions of the Irish tax revenue were by the state. Intra-union trade had to be affected. This was also very quickly found to be the case. Competition had to be distorted. That was also very easy to determine, because it gave a specific company an advantage, and therefore that it didn't give other competitors. And then the issue is that, and this is the disputed aspect, is that we have to have a selective advantage. Now, according to the Commission, the taxable profit was calculated on the basis of the profit allocations method endorsed by Ireland, and they departed from a reliable approximation of a market-based outcome in line with the arm's length principle that we talked about earlier, and therefore were a selective advantage. So the Commission entered into an assessment of the method that was necessary for the calculation. So we see that actually, again, it also found that because, let's say, how shall I explain this in terms that we can, so because it seemed that these profits were allocated so to a company that didn't seem to have any presence, as I said earlier, it was for Apple to demonstrate that they really amounted, that this company really had some kind of activity. So in a way, it's found that it was for Apple to prove that there was some kind of rationale, justification behind this profit allocation that seemed otherwise quite random. Now, according to the court, the reason why Apple lost is because it actually, the court found that Apple still needed to prove, the burden of proof was still on the Commission to prove that that profit shifting had indeed been done in a way that did not meet the arm's length principle. So a few things that that are important about the decision of the General Court is that it dealt with whether or not this was the disguised tax harmonization. This was not supposed to be the case according to the court. So it did not believe the arguments put forward by the parties that this was a way of harmonizing issues issues that are in the hands of the member states. And another issue that was really important is that the court acknowledged that the arm's length principle can be applied in the context of state aid and to determine the validity of tax rulings. Now, so the case really fell short in the burden and standard of proof. Just some, as a general assessment of what the case law tells us in this case is that, really what we see is that indeed, the court recognized that state aid is applicable in these cases. State aid legislation is applicable. In fact, the idea is one of the advantages why the companies like these tax rulings offered by the member states is that the systems, they get some predictability as to the tax they have to pay. Now, reducing predictability is no bad thing if we bear in mind that this might actually amount to something that is harmful, and also actually so much for predictability if these tax rulings might actually be unlawful. So actually predictability is perhaps somewhat more of an illusion than a reality. So that's something that I discuss in the paper. Now, another thing that I discuss in the paper that is maybe relevant here is that perhaps unwillingly, some unintended outcomes of these recent decisions by the General Court is that, well, first of all, the technology protectionism narrative is somewhat challenged. We hear a lot in the US, even I've heard Obama and, well, of course, Trump say issues relating to the fact that the European Commission and the action taken in Europe by the European institutions is a way to fight or to take profits from American companies, the big tech companies that are doing so well, and the Europeans are not entitled to doing so. And of course, this is far from the truth. EU competition law operates very differently. It focuses on market power. These companies have market power, hence why we have so many cases against them. And also, we just see that at right now, the way that competition law applies in Europe is perhaps, we've never gone the Chicago way. We've never adopted the same standards. And therefore, to think of EU competition law in the same way as US antitrust is, I think, a mistake in my view. And I think the outcome in these cases is just a response or a consequence of that difference. And of course, state aid is not something that is regulated in the US. And interestingly enough, the only case that the Commission has won so far, it relates to a European company. The American companies have won. So the idea that the system in Europe works against American companies, I think, is definitely challenged by this outcome and breaks that narrative. As you know, if we look at the past, other cases have also done. But the Apple case, I think, because it's been so public, it really reflects that. We could also talk about the thoroughness of judicial review. Of course, this shows that really the court, we can see, really went into every single aspect of this decision. So again, it shows that judicial review takes place and is done normally, at least in a thorough manner. So just to conclude and to open the discussion, I think I see state aid as a suitable tool to combat tax avoidance and harmful tax competition. Now, of course, we still see, I think, harmonization is still the best way, and solving future issues is really the way to get a final, a very different future, and that's what we really care about. But it's no bad thing to be able to really scare the companies a bit and tell them, you know, we can resort to state aid. You might actually be paying what you're doing now, might have consequences in the future. You may have to pay the tax that you are not actually paying now. So and the Commission is still continuing to open cases against other companies, against new companies. So it's not giving up just because it's lost a couple of cases, and it has won on principle. So it would be interesting to see on the grounds on which it challenges the decision of the General Court, because it won on the main aspects. So the thing is, perhaps to make the strategy more credible, the Commission might have to rethink how to meet the burden of proof, if there's anything it can do to really work towards meeting that evidentiary burden, if, of course, the Apple case is decided against it, which still needs to at the Court of Justice. So yeah, we need to see how that goes, and then we will see really how strong a tool state aid is to combat these kinds of practices. And I leave it here, and I hope that we can open the discussion.
Thank you. Thank you very much, Sandra.